Hello, everyone, and welcome. I'm Jenny Dodson, and I'm the Executive Director for the Healthcare Reform Center and Policy Institute, as well as the Corporate Health and Wellness Association. I want to thank those of you who are our certification participants for the Certified Corporate Wellness Specialist Program and the Certified Healthcare Reform Specialist Program. As you know, we provide continuing education and updates for you as participants, and this is just another one of those great updates. We're very, very lucky to be joined today, and I'll be introducing them shortly, Groom as well as HealthMine, and two great speakers, and so we're really excited to have them. Briefly, we're here for continuing education. We bring education to the masses through our portals online as well as in person. And if you're not a certification participant, we'd love to help you join this and gain new knowledge. So definitely join me, and feel free to reach out if you'd like to learn more about these programs, as our main goal is to bring education and updates to our participants and to our constituents that participate with us. So without further ado, I'm pleased to introduce the speakers today. Seth Peretta is a principal at Groom Law, where he advises clients on a wide range of federal tax and ERISA matters regarding employee benefits and insurance. Seth's practice brings together his deep knowledge of the technical rules that govern employer-sponsor arrangements with Washington-facing administrative practice before federal agencies, including Internal Revenue Service, as well as the Department of Treasury, Labor and Health and Human Services. So Seth is nationally recognized. In fact, he's done hundreds of presentations, I know to be true, just as I watch the various presentations that go on. He's recognized in the field of ERISA and employee benefits, including and specifically with respect to the Affordable Care Act. As co-chair of the health and welfare practice of the firm, he frequently counsels clients, including insurance companies and third-party providers, on all aspects of the ACA, including plan design, business strategy, as well as product development. Seth's very well versed in all of these things, as I've mentioned, and we're also very lucky to be joined by Bryce Williams, and he's the CEO and President of HealthMine. HealthMine is a leading consumer health engagement company that has developed wellness industry's first and only personal clinical engagement technology platform. So it's the only out there, and it's really awesome technology. Bryce is the leader. He's a pioneer in healthcare consumerism, having co-founded Extend Health, Inc., and he was president and chief executive officer from 2004 through the company's acquisition by Towers Watson in 2012. He also has a deep understanding of the challenges employers face in controlling healthcare costs, and his expertise lies in the practical application of healthcare reform policy to the employee benefit design. So we've just got two great experts today that are going to be talking about specifically the EEOC and the long-awaited issued proposed regulation with respect to the employer-sponsored wellness plans. So great guidance that will be provided today. Our first up is Seth, and I am going to hand the reins over to you, Seth, and ask that you go ahead and take over. Real quick housekeeping note. If you have questions, please populate those questions in the Q&A module. It's located at the bottom right of your screen, and you can populate questions there and let us know, what you're thinking as we go through the presentation. And at the end, we'll have time for your questions to be answered by our experts today. I'll be reading through them and try to get to as many as I can. So, Seth, without further ado, I'll give you the reins.
Thank you very much, Jenny. Very much happy to be here and appreciate the invitation. Little did I know that I was going to need a webcam for this broadcast. Had I known, I would have hired like a face double to be on here today. But needless to say, I'm very happy to be here, including with my large head So hopefully I think we have a lot of fun content to learn about today, and I'm really happy to be joined with Bryce from HealthMine. Obviously, he really is at the forefront of a lot of the things we're going to talk about today, so happy to be partnering with him. Our agenda for today is we are going to do an overview of the new rules that have been proposed by the EEOC on wellness. We're going to try to break down the rules to help you understand how they apply to employer programs. And we also want to highlight areas of potential risk for you and for your company, and also discuss recommended employer actions and next steps. These are just proposed rules, and so I think a lot of employers have been looking at them and saying, what do I do about these rules if I'm not squarely compliant with them? I don't obviously fit with them. They're just proposed. Do I make changes now? Do I wait for the final rules? What do I do? We're going to talk about that today as well. So in terms of the actual regulations themselves, they were published on April 20th of this year, so very recently, effectively just a few weeks ago. Comments are due on them by June 19th of 2015. I think the EEOC is expecting a wealth of comments to be submitted both from employers, wellness providers, disability rights groups, consumer rights groups, etc. One thing the rules do not address is how Title II of GINA, which is the Genetic Information Non-Discrimination Act, affects an employer's ability to basically use spousal HRAs or spousal biometric screens. This is an open issue, and I think folks had hoped that the proposed EEOC regs would touch on not only the ADA, but also GINA. Unfortunately, they do not touch on GINA. As we'll talk about a little bit later, we are expecting that future EEOC rulemaking will be issued with respect to GINA itself, perhaps by the end of this summer. I'm going to turn over now to Bryce to talk about sort of the importance of health data and how to really make it be helpful with respect to employer wellness.
Thanks, Seth. It's great to be here and great to be on. Thanks, Jenny. And my role on this call is to try to provide an employer perspective, or as someone that manages wellness programs at both health plans and employers, talk about the potential impact, the complications, and different attributes of what's been proposed that hopefully we can figure out how to navigate through and around, and then also activate each one of you as to how to comment and how to organize your thoughts of how you've designed your plans and get that information to the regulators before the comment period expires here in a little less than a month. So just some quick background. One out of every 2 people on employer-sponsored insurance has some form of a chronic or acute condition. These conditions, as we all know, the 80-20 rule, generate 80% of the cost inside these plans, even though it's oftentimes a very small percentage of the employees. So one of the things we discovered as we've gone to try to implement clinical data analytics, what we call personal clinical engagement, essentially a wellness 2.0 kind of plan, is so few of folks actually know their numbers and use these metrics to start. So part of the EEOC regulations is dealing with your ability to run health risk assessments and biometric screens. And we think part of our comment to the staff will be, very few people actually have these numbers, and in a lot of conditions, this is very important that they know, not the least of which, of course, is the blood sugar level. When you see the out statistics that by 2035, roughly 1/3 of Americans will be either pre-diabetic or in type 2 diabetes, the fact that today only 17% of people know their number is a problem. And we've also talked about how employees, and we will talk about, have a hard time just understanding health information that they get from their employer about what they have, and we think that's going to inform some of the notice requirements that are in here. So Seth, why don't you go to the next slide? So this is one of our customers. We thought we'd share a couple of human stories while we're also talking about the legal implications. Here's a gentleman that worked with one of our clients, one of their employees, used our standard biometric screening mechanisms and discovered significant hypothyroidism. Through the implementation of a robust wellness program that, again, was put in place by his employer, in this case the JFK Medical System outside of New York, he was able to take control of his health care, lose a significant amount of weight, and basically regain his health. So not lost in all of these technical matters and technical discussions is what about the people for whom these plans were originally designed and whom they're there to try to incent them to do healthy actions and take control of their health. Here's another woman, Mary Beth Quinn, same thing, lost 48 pounds in a year, based upon just getting basic BMI and blood sugar data through a biometric screen as a start of a plan with her employer. So again, there's the data here, there's these human stories, but also there's the story that these wellness programs exist at our clients that help them look good, feel great, be better employees, show up for work, do great work, and above all else, have great lives. So I'll be talking as we go through here, kind of intermixing some stories and things that we're hearing from employers about how these regs might affect their trying to do these things and create these super success stories inside their employee populations.
Thanks, Bryce. I think that's actually really important because, as we're going to talk about today, there are a lot of rules that these EEOC proposed regs include, and we're going to talk about it technically around what the rules are and how they work. But I think it's going to be really helpful if we provide sort of factual scenarios and draw out real-life examples and what these regs really mean for wellness programs. So that's going to be, I think, very helpful today. The first thing here on this slide is be careful, know your category. What this really gets at is that in order to understand how the proposed regs potentially apply to a wellness program or your wellness program, you have to figure out which of the following three categories your wellness program fits into. And we're going to drive this home in a couple ways here. One is, the first category here is an employee health program, or really what we're thinking about here is wellness. Employee health program is the phrase used by the EEOC reg. But it's a wellness program that is not part of a group health plan and does not include either a disability-related inquiry or a medical examination. And so let's break that down a little bit, unpack it. Right? First thing is it's not part of a group health plan. Well, what is that? For purposes of federal law, a group health plan is generally a plan that includes what is called 213 medical care. Medical care that if an individual went and paid for it at their doctor, they could potentially take a deduction on their annual federal tax return. So we're looking at what is often called 213 medical care. Does the wellness program have any medical care in it? So things like biometric screens, things like cotinine tests, things like disease management or wellness coaching by a licensed provider. Also, if your wellness program has incentives tied to employer-paid medical care, like a premium subsidy or a premium rebate, or seed money into a flexible spending account or health reimbursement arrangement. All of those things would likely result in this arrangement potentially being part of a group health plan. The second thing here is that it does not include a disability-related inquiry or medical exam. For purposes of the ADA, what is a disability-related inquiry is quite broad. Asking someone, for example, if they have high glucose, what their BMI is, do they suffer from hypertension? Many of the questions that are on a typical health risk assessment questionnaire would result in a disability-related inquiry. Notably, and we're going to talk about it later on today, asking someone if they smoke is not a disability-related inquiry because smoking is not a disability under the ADA. A medical exam. What is a medical exam? For purposes of the ADA, it takes a very broad view of medical exam. In talking with staffers at the EEOC following the issuance of these rules, they've indicated that things like a biometric screen, a weigh-in, a cotinine test, a cheek swab, a blood draw, any of those would qualify as a medical exam. So in this first category, to fit into this first category, you're not part of a group health plan, and you don't include a disability-related inquiry or a medical exam. Now moving on to the second category here. It's a program that, again, is not part of a group health plan, but includes a disability-related inquiry or a medical exam. So it may involve a health risk assessment or a biometric screen, but for example, it doesn't provide, well, if it's not part of a group health plan here, I guess it would probably have to be something that just involves a disability-related inquiry. So in theory, it would be something that uses like a health risk assessment, and the incentive is provided perhaps in the form of something other than medical care, so like a cash incentive. This third category here, it's an employee health program that is part of a group health plan and includes either a disability-related inquiry or medical exam. And we'll talk about an example here, but this might include something like a biometric screen, maybe a BMI or cotinine test, and then tied to that is perhaps premium incentives or employer seed money into a medical savings account. So in order to understand in order to understand how the proposed EEOC rules apply to you, you first have to really understand which of these three categories you are in. This is a chart that we put together that actually really breaks down the proposed EEOC rules into the three categories. Each of the columns there, going from the top to the bottom of the chart, are the three categories I just mentioned below. So in order to understand how this chart works, you first have to figure out, again, which category you're in. Just to reiterate, Category 1 here is one that is now part of a group health plan and does not include a disability-related inquiry or a medical exam. An example, if a person attends a health fair, they earn a pair of free movie tickets. This is not part of a group health plan because there's no medical care going on here, nor is there any employer-paid health care. There is no disability-related inquiry or a medical exam. Category 2, again, not part of a GHP, not part of a group health plan, but it does include a disability-related inquiry or medical exam. An example here would be to complete a health risk assessment to earn a cash reward. The health risk assessment qualifies as a disability-related inquiry, but again, there's no medical care here happening, nor are there any incentives provided in the form of employer-paid medical care, so there's no part of this is part of a GHP. Third category, again, just to reiterate what we went before, here's an example: complete a biometric screen or HRA and earn a rebate on insurance on an insurance premium, or avoid a surcharge. So here, because you have a biometric screen, it would likely qualify as part of a group health plan. And then because the rebate here is, because the incentive here is paid in the form of an insurance premium rebate or surcharge, we have other medical going on. Now the HRA here and the biometric screen would qualify as either a disability-related inquiry or medical exam, and so we're squarely in Category 3 here. Let's see here. So before we go into how the rules specifically apply, I think one thing that we do want to talk about here is about incentives and basically how consumers may want incentives in their wellness programs.
Yeah, thanks, Seth. So what we do each week is we survey roughly 2,000 members across the million lives that we manage, and we ask them what makes meaning for them in terms of the design of their wellness program, how do incentives actually incent them to engage and take action, and how does that work? And we're getting back some very interesting data. We've been doing this only for about the last 8 to 10 weeks. And it clearly, incentives work. There's all kinds of different incentives, whether it's the carrot or the stick, whether it's cash or a premium rebate. But there's no question in terms of activization. We find that the consumers are very interested in these incentives and these wellness programs. However, a lot of the incentives that are offered currently inside program designs are not that meaningful. So they may not tie back to the actual health status. They may not make specific health recommendations. They may just be sort of fun things that you do at a health fair and yet not really tied to my health and the personalization of my treatment, which we find is actually creates higher meaning. And what we see happen also is the programs that are out there and offer cash, a lot of times people don't fully utilize those incentives. They don't take them up on it. They don't do the things that we're trying to motivate people to do to go take action. So again, part of this exercise of going through these slides and looking at this proposed reg is how does this change what I know my employees want and like, and how should I think about that going forward?
Yeah, and I think that's a great way to tee into these rules because, as we'll see, the rules in some respects, depending on your current design, may not actually affect it at all. And depending on where the final rules go, may potentially affect them, but I think at this point, really understanding how the rules apply to your program is going to be important to thinking about what incentives you can and cannot use. The first thing I do want to highlight here is that under the proposed EEOC regs, one of the requirements, and this borrows a lot from HIPAA, which are the rules that traditionally employers have looked to in trying to design legally compliant wellness programs, is that the programs must be reasonably designed. And this requirement applies across all three of the categories we've talked about today. What does it mean to be reasonably designed? It means it must have a reasonable chance of improving health or preventing disease. It must not be overly burdensome. It must not be a subterfuge or otherwise violating the ADA or other federal non-discrimination rules. And it must not use a highly suspect method to promote or prevent disease. The good news here is to be reasonably designed, the method used need not definitely have sort of clinical effectiveness that's been substantiated previously by a third party. On the other hand, you can't use a highly suspect method. Also, it cannot be used as a subterfuge for violating the ADA. So these are the rules that are set forth in the new proposed EEOC reg, and they apply to all three categories of wellness programs that we're talking about here today. The second requirement here, and I think some folks have looked at this as a very new requirement. I think some have thought maybe it's not that new, but I think there's honestly a fairly varied perception of whether this is new or old or long-standing. But in the EEOC proposed reg, they make clear that you must provide reasonable accommodation. And as you see again here, this applies across all three types of categories. In terms of what does reasonable accommodation mean, and just to be clear here you'll see in this slide, it applies whether or not the program has a disability-related inquiry or a medical exam. But here's some examples that are set forth in the proposed reg. For example, if an employer offered a nutrition class, regardless of whether a healthy weight is required, you may be required to provide a sign language interpreter for a hearing-impaired employee. Similarly, if you have someone who has to complete written materials at a desk or watch TV and they are hard of sight or visually impaired, then they may need to be provided with a reasonable accommodation, such as large print or braille or et cetera. So many people look at this and say this is really what the ADA always required. Some people have looked at this and thought that this is problematic, that employers may not have been going and doing these behaviors previously. I think honestly it's probably an employer-by-employer case, but this is definitely something that is set forth in the proposed reg, and we anticipate will find its way into the final reg as well. The second requirement we're going to talk about today is that it must be voluntary. And this really goes back to where most of the legal uncertainty has been for employers under the ADA, which is the ADA has an exception for voluntary wellness programs. What does it mean to be voluntary? Well, the EEOC has historically said a voluntary wellness program is one that does not penalize, but they've not actually defined what it means to penalize. The proposed regs, thankfully, provide, I think, some helpful guidance for employers as to what it means to be voluntary. As you'll see here, though, if you're in Category 1, your wellness program is not part of a group health plan, and it does not have a disability-related inquiry or medical exam. In that case, you are not subject to the voluntary requirement. So remember our example where if you go to the health fair, you get movie tickets? That arrangement would appear to not be subject to these requirements. On the other hand, Category 2 and Category 3 would be subject to these requirements. A couple things I do want to highlight about these requirements, which is one, you'll look over there at the first bullet under voluntary. It says it must not require participation. And then the second bullet here says must not deny coverage under any group health plan or particular benefit package within a plan, or limit the extent of benefits solely for not participating in the wellness program. This is, I think, a very important rule that people should be thinking about because, for example, it seems to be a ceiling on activities that otherwise would have been potentially permitted by HIPAA. Here is one example here. An employer offers two benefit packages, a low-value option and a high-value option. To be eligible to enroll in the high-value option, an employee must agree to take an HRA or undergo a biometric screening. This we call a gatekeeping example. So if the participant actually completes the HRA, they're able to get into the high-value option. Otherwise, they're going to be in the low-value option. Under HIPAA, it was permissible. There was no reason to believe that under the HIPAA regs that approach was somehow impermissible. However, under the proposed EEOC regs, based on the language that I read to you, it appears to be at risk. I guess one question for you, Bryce, is in terms of working with employers, have you seen them wanting to go in this direction, and what do you see as potential downstream consequences if the EEOC were to include this in their final rule?
Yeah, so we think this is going to be a big area of comment for employers, and it's driven by a couple of things. One, as you mentioned, under the ACA, these kinds of activities we're very much fine with designing into your program. The other dynamic happening here is with the 2018 Cadillac tax, the primary tool in employers' playbook seems to be, and will continue to be, moving to high deductible based plans, whether tied to HSAs or not. and moving more and more towards employees having more first dollar exposure. And so as part of that, they have created two-tier type of levels where if you do certain things, they can allow you into the higher benefit value plan. If they don't, they would offer a more basic benefit value plan. And part of that strategy and design is also now found in the private exchanges that are covering millions of lives. Many, many companies, including Sears and others, are moving towards these private exchanges that have multiple levels, whether bronze, silver, gold type plan designs, that are at different levels that can have different aspects of these kinds of things and asking for biometric screening and HRA. So a big push because of the Cadillac tax and because of the expansion of private exchanges at major employers appears to be in need of comment from employers explaining their strategies potentially to EEOC staff so they understand that the dynamic here that appears at risk perhaps shouldn't be, but we'll see where this goes.
And I do think, in talking with the staffers at the Commission following the issuance of the proposed reg, it does appear to be the case that they are, I don't want to say looking anew at this requirement, but looking at whether or not maybe it goes too broadly or whether there is some flexibility that they could build into to ensure that employers still have discretion to create incentives that drive people to engage in healthy behavior in order to access potentially a higher value option. It does seem to be the case that I would expect that any final rule would continue to have a rule that says basically if, in order to access any comprehensive major medical care, you have to participate. That rule would continue to be a violation of the ADA under the final rule that we're expecting late summer. On the other hand, will the EEOC ultimately concur that an employer could potentially gatekeep into a benefit package in order to encourage healthier behavior? And I think that's where the employer community may be able to put in lots of comments and explain why this makes sense. And so long as I'm offering comprehensive major medical coverage as the default, don't take away an important tool in our tool belt for driving healthy behavior. So I think, as Bryce mentions, comments probably will be forthcoming from the employer community to a great extent on this issue. One thing I do want to highlight on this slide, slide 31, is just that there is a requirement here, which is that you must provide a special notice to employees in order for the arrangement to be voluntary. You'll see here that if you're in Category 2, where you are not part of a group health plan, the notice requirement does not apply, at least in its current form under the proposed reg. However, if you are part of a group health plan, it does apply. And you'll see here that if you look at actually what's required, part of the notice says it must be written to describe the types of medical information that is sought and the specific purpose for why the medical information will be used. These are notice requirements that actually do not align with most HIPAA privacy notices. And so employers who have wellness programs that fall into this third category will likely need to look at their existing notices that they use with their wellness programs to see if they need to be updated to comply with this new notice requirement. Again, just proposed, not yet final. But if these do find their way into a final rule, you will certainly want to pay attention to them if you fall into that third category.
And Seth, there's another dynamic happening with that that's actually very interesting, which is, and we were even talking to a client this morning about this, when you start to receive the sheer volume of notices that came out of the ACA and then these other ones, and now there's a net new one, at what point do you achieve notice fatigue where people don't even pay attention to it or they don't really understand what the information means? And there's a worry with this notice requirement that is potentially new that we're starting to get into that gray area.
Oh, absolutely. I think it's a great point, Bryce. And I'm sure if all of the attendees on today's call could vote in favor of your last comment, we'd see a lot of votes. I think that your point about notice fatigue is quite relevant, and I think post-ACA, the burden on employers to notice individuals has gone through the roof, and this would, again, be, to your point, just another new or expanded notice requirement for employers. So I think it's a very valid comment. Hopefully we'll see it before the regulators as part of the comment process. Moving on now, one other requirement that's in the proposed reg is that you can provide incentives of a de minimis amount, and this applies to all three categories. So if an incentive is de minimis, you can apply it with respect to any of the three categories. Now, what is de minimis? Unfortunately, the regulations do not say. No specified dollar was set forth in the proposed regs. Presumably small dollar incentives are probably permissible. One of the staffers with whom we spoke to sort of threw out $150 as potential de minimis threshold based on their GINA regulation. Certainly the movie tickets for attending a health fair in our example from before would seem to be de minimis. The issue, though, is if you go beyond de minimis, what happens? Well, the EEOC reg says that you can provide incentives of up to 30% of the total cost of self-only coverage. But what's interesting here, well, is first of all, this requirement does not apply to Category 1, this limitation. What's slightly concerning, though, is that the way the EEOC proposed regs are drafted, this requirement, or this permission to use incentives of up to 30% of total cost of self-only coverage, appears to only apply to Category 3 and not Category 2. So looking at Category 3, this would be a program where you have clearly have a biometric screen or other sorts of medical services as part of your wellness program, maybe disease management or health coaching by a licensed practitioner, or you have subsidies or incentives being provided in connection with health care. Whereas with Category 2, the regs seem to be written in a manner that would not allow even the use of the 30% of the total cost of self-only coverage incentive. And so take the case where I have an arrangement that says if you complete an HRA, you will receive $300. That does not appear to be eligible for this special rule that allows for incentives of up to 30% of the total cost of self-only coverage. Why is that? Well, it appears the EEOC is highly skeptical of employers requesting health information from their employees. On the other hand, they were trying, I think, to not supplant HIPAA, because HIPAA is a tri-agency rule. Congress obviously loves the ACA, and, well, I don't think Congress loves the ACA. Congress obviously loves HIPAA because as part of the ACA, they not only codified the HIPAA regs in the ACA statute, but they also increased the potential incentive cap under HIPAA from 30 to 50%. So I think EEOC, confronted with that reality, was trying to say, okay, we're going to do our best to live within HIPAA. Well, HIPAA only applies to group health plans. And so as a result, if you look at this, because HIPAA only applies to group health plans, they've given a 30% threshold based on the total cost of self-only coverage to Group 3 or Category 3, which is a wellness program that's part of a group health plan. Where it's not part of a group health plan, the default rule of the proposed reg kicks in, which is nothing more than de minimis. Clearly problematic, likely to affect, I think, wellness plan design. And so, Bryce, what are your thoughts as to whether or not, if that appears nowhere to become no in the final rule, whether that could have an adverse effect on wellness plan design for employers?
Well, again, there's really not a bright line test of what is de minimis, and a lot of the different strategies that most employers are using actually involve way more than what you would categorize as de minimis dollars. These are very serious programs, many of them. But if you want to lead to the type of health results that we saw from a couple of people at the top of this call, it's going to have to be more than movie tickets. They're going to move the dial in terms of getting people to engage in their health. And certainly the comments that we're hearing that are coming from employers around this type of rule, they're looking to try to continue to do what they need to do to actually generate engagement. And it is going to move beyond some of the more social or gamification kind of things. It's going to get involved with people knowing their numbers, clinical analytics, and doing a deep dive as to, based upon the data that is coming out of my claims set, what should I do next? And then how can that incentive or the way the plan is designed incent me to actually take action and start to progress myself away from becoming an acute or a chronic. So those things, unfortunately, we believe are way above the de minimis threshold. And we suspect at a certain point here that staff is going to catch on to this, and we'll see what comes back in the final reg, but we know there are a lot of comments coming in this sector.
Thank you very much. I mean, one interesting thing I know, Bryce, you and I've talked about is that pre-EEOC regs, there was some, I think, desire on the part of wellness plan designs to actually not be part of a group health plan because then you avoided HIPAA. And so you then did not have to get into the HIPAA privacy issues, and the incentive caps did not apply. Interestingly enough, if the EEOC final rule were to look the way it looks here in this red circle, and effectively we could only have de minimis incentives with respect to that Category 2, which are programs that are not part of a group health plan, then it seems like you suddenly are now trying to go the other way, which is now you're trying to push your way back into a group health plan to find your way into Category 3. So it is interesting how HIPAA created an incentive to potentially keep your program outside of being a GHP or a group health plan, whereas now the proposed rule seems to be trying to push you back in. One interesting question is around HSA contributions. Do contributions to an HSA as an incentive cause a program to be part of a group health plan so that you would find your way into Category 3 versus Category 2? I actually think it's pretty interesting. Generally, if that money is coming from an employer, that's going to be employer-paid health care within the meaning of the federal tax code, so I think it could still throw you into Category 3. But I think it's an open question because as a general matter, health savings accounts are not group health plans for purposes of ERISA under federal law right now. So if all you have is HSA seed money and you don't have other medical care, significant medical care, or other sort of medical care-based incentives, all you have is HSA seed money, that'll be an interesting question for you to think about once that final rule comes out.
Well, also, there's one other thing, Seth, here, too, which is kind of a new topic I've not seen anybody really comment on yet, is for those large employers, especially retailers and those, in the food industry or what have you, if you're offering some form of a wellness benefit to those outside of the GHP, does the value of that then somehow disqualify you from qualifying for help on the public exchanges and buying your own plan, and therefore negate a good part of what the ACA was intended to do, which is allow people who don't qualify for group coverage to be able to secure their own and get premium assistance? Does offering those, what is that line of how much money, and then starts to disqualify people or drive up their cost for these part-time and seasonal workers to do that? And I think that's an unanswered and unaddressed question also.
Absolutely, and actually you made me realize one thing I neglected to raise at the start of the webinar, which is around how much medical is enough medical to cause something to be a group health plan. As I mentioned, to be a group health plan under federal law, you have to provide medical benefits or services that, if paid for by a private taxpayer, could be, in theory, deducted on their annual Form 1040 or federal tax return. The regulators have consistently dodged the question of how much medical care do you have to have for an arrangement to qualify as a group health plan. And unfortunately, they've been unwilling to answer it. They've effectively solved the problem through other means, but as you can see here, it really is important in figuring out whether you're part of a group health plan as to figure out which category you're in. So unfortunately, there is no bright line. If you have this much medical care or this much employer-based medical care incentives for your wellness program, that throws you into being a GHP. So there is some lack of clarity at the federal level, and that is replicated into the EEOC proposed reg, because the EEOC refers back to the ERISA group health plan definition. All right, now moving on here to our next slide, I wanted to highlight something that's pretty important in terms of the difference between the HIPAA regs and the proposed EEOC regs. The HIPAA reg allows you to go to incentives that are 30% of the total cost of coverage in which the individual is enrolled. So if I have an employee and a spouse, and they're both and they're enrolled in family coverage or employee plus one, and they're both eligible to participate in the plan, the 30% incentive cap is based on the total premium cost of that employee plus one or family coverage. If the spouse can't participate in the wellness program, then for the employee, the incentive is capped at 30% of the cost of self only. But if both the employee and the spouse can participate in the wellness program, then the HIPAA cap is 30% of the total cost of coverage for that employee plus one or family coverage. The proposed reg is different. The proposed reg caps the incentive, and again, this is for this is really for programs that are part of a group health plan. It allows for an incentive of up to 30% of the total cost, but it's of only self-only coverage. It's not the coverage in which they're enrolled. When those regs came out, I think that caused a lot of concern. People read this and said, well, gosh, what if I have an employee and spouse participating in a wellness program and they're enrolled in employee plus one coverage? Is the total incentive amount for the employee and the spouse 30% of the cost of self-only? That's a lot less than the cost of 30% of employee plus one coverage. In talking with EEOC staffers, it's pretty clear that what they meant, or what they tried to convey, although not very well in the reg, is that the 30% of the total cost of self-only coverage only applies to the employee. Why is this? I think they are concerned, at least based on statements of the staffers, that the ADA on its face only applies to the employee. And notwithstanding certain legal concepts like associational discrimination, et cetera, they are concerned that they cannot reach to spouses and dependents who participate in wellness programs. So the 30% cap would be a 30% cap on self-only coverage, but with respect only to the employee. And so as we'll see in the next couple of examples, it may be the case that depending on the way your coverage is tiered and priced, this may or may not actually have any effect on you. So if we look here at this slide here, an example of the 30% rule. In this example, the employer offers medical coverage to its employees as well as spouses and dependents. Self-only coverage costs $4,000 per year. Employee plus spouse coverage costs $14,000 per year. So you see that employee plus spouse coverage is exactly 2x of self-only. It's $14,000, which is twice as much as $7,000. In accordance with HIPAA, the employer provides a premium incentive of 30% of the cost of coverage for employees and spouses who complete the wellness program. Because they can both participate and they're both enrolled in Employee Plus One coverage, the maximum incentive that could be used under HIPAA is $4,200, or 30% of $14,000, the coverage in which Sue and Bob are enrolled. Now, under HIPAA, this would comply, $4,200, 30% of $14,000. Under the EEOC regs, however, it appears at risk because if you look at the text of my example, in order for Sue or Bob to earn any incentive, they both have to complete the wellness program. So if Bob doesn't complete it, Sue gets nothing, and if Sue doesn't complete it, Bob gets nothing. But if Sue and Bob complete it, they get 30% of $14,000 or $4,200. Under HIPAA, that works. The bundling of participation by the spouse and the employee is not prohibited. Under the EEOC regs, however, it appears at risk, since the incentive that applies to Sue is $4,200 in excess of $2,100. $2,100 is 30% of the cost of self-only coverage. If you unbundle in this arrangement and you say, okay, we're not going to require Bob and Sue to both participate for either one of them to earn an incentive. If Sue participates, she gets half of $4,200 or $2,100. If Bob participates, he gets half of $4,200 or $2,100. In that case, there is no problem under both the EEOC reg or under HIPAA. And so, again, here, what's important here is the cost of the coverage, specifically Employee Plus One, relative to self-only, plus looking here at the bundled nature of the program. One question for you, Bryce. How often do we see, or do you see bundled programs like that we have in this incentive?
Well, we were looking at some data just in the last 24 hours, and you'd be shocked at the sheer percentage of spouses who waive coverage from their spouse under a plan, and maybe they select coverage at their other employer. And so how do you start to keep track of this? And then also from talking to clients, the ACA was very clear about its wanting to incent and expand wellness programs to try to achieve better health outcomes. And then you see a proposed reg like this that seems to be in contrast to what we had just received a couple of years ago. And our clients are asking us what's happened or who's doing this and how does this work interrelatedly with the ACA regs that clearly took a different slant on how much I can invest in my wellness programs. So I think you kind of have this underlying conflicting information going back and forth, and employers are confused. And then when you look at this bundling concept, you can only imagine the actual employee plus one, employee plus spouse. How are you going to figure this out in your plan design? This adds, we think, another layer of confusion, and clearly cutting back to 30% of just individual or self-coverage is a big reduction in what employers can do in terms of the value of their wellness programs.
Yeah, I think that last point, Bryce, is really important. If the final rule were to reflect the current language in the proposed rule, which could be read to the total incentive for both employee and spouse at 30% of self-only, that likely would be a huge reduction. The EEOC rule would be a ceiling in terms of wellness program incentives for probably many, many employers, may cause them to reduce their incentives. Hopefully that what we see in the final rule at least reflects what the staffers seem to be saying to us after the issuance of the proposed rule, which is that no, the 30% only applies to the employee. The employer can do what they want with respect to the spouse and dependent. To Bryce's point, it does raise a level of complexity that seems unnecessary, but but hopefully they will at least clarify that in the final rule. Here is an example, however, where even where you have an unbundled arrangement, you could still find yourself having a problem. So in this example, it's the same exact arrangement with Sue and Bob, except the cost of employee plus one coverage is $15,000 per year instead of $7,000. Because the $15,000 is more than 2 times the $7,000, if you look at this under HIPAA, the total incentive could be $4,500 for Sue and Bob because that's 30% of $15,000. But if you look at the EEOC reg, which again focuses on Sue because Sue is the employee, it says Sue's incentive cannot be more than 30% of self-only. 30% of $7,000 is $2,100, which is less than $2,250. So even if we unbundled the arrangement here, because Sue could get $22,250 of incentive under HIPAA, but that is more than the $2,100 that would be permitted by the EEOC regulation, we would have an incentive problem. We would have to effectively reduce Sue's incentive down to $2,100. So as you can see here, this does create a problem because effectively the employee plus spouse coverage is more than 100% of the cost, or more than 200% of the cost of self-only coverage. All right, the last thing I wanted to highlight, and this is a pretty significant distinction as well, although in terms of who it will affect, I think it's going to be a question of where your program is or where you want it to go. I'm really intrigued to hear what Bryce's thoughts are on this. One of the requirements is that you can provide an incentive of up to 50%, just like you can under HIPAA, but of course for the EEOC it's 50% of the total cost of self-only coverage with respect to the employee if they are enrolled in a qualified smoking tobacco cessation program. So under HIPAA, it can be 50% of the total cost of coverage for which they're enrolled with respect to a qualified smoking cessation program. It is a special area where the regulators have said you can go up to 50%. The proposed EEOC reg keeps this rule. It allows you to go up to 50%. Of course, though, as discussed, it's only based on the total cost of self-only coverage because this rule drives to the employee, apparently, not to the spouse. But what's interesting is you can only go to 50% if you are not using a medical examination or disability-related inquiry. As we talked about, if you have a cotinine test or a blood draw or a cheek swab, the ADA, the EEOC staffers with respect to the ADA believe that would qualify as a medical examination, and therefore that would not be permitted. On the other hand, as we talked about, smoking is not a disability. So if I merely ask you if you smoke on an HRA for purposes of figuring out whether you get the 50% incentive or the 50% surcharge, that would be okay under the proposed EEOC reg because we do not have a disability-related inquiry there. Now, obviously, many employers, I think, Bryce, and interested to hear, I think we're moving away from the use of questionnaires on smoking to more quantifiable biometric screens. Is that your experience at HealthMine?
Well, not just biometric screens, but if someone were not to be asked a question or there wasn't even a questionnaire, eventually, and sometimes very soon, you will start seeing claims information come back on a person that will identify them clearly as a smoker. And so at that point then, does that information need to flag someone that either did not raise this information or didn't offer it, or perhaps even in the questionnaire was untruthful? And it puts employers in a very uncomfortable position of trying to manage the truthfulness of their employees around smoking cessation. We can tell you without question that the employers feel very strongly that the 50% prior limit was something that they need to help incent and move these people towards program management just based on the total cost profile to the employer. And that moving to 30%, the question we keep hearing is, what does this achieve by cutting that back? What is the positive result does it achieve? What do you give up in the protection? What do you leave on the table in exchange for this kind of move? And the answer is typically the invocation or the offering of very effective smoking cessation programs. And we'll see where this comes back, but this certainly is an area of high emotion for employers.
Thank you very much. I think one thing to talk about is, and you may have touched on a little bit, are the incentives that you see around smoking cessation programs?
Yeah, we see all kinds. again, some of these designs here, you see some of the information we get back. Still, today, only 30% of programs actually have smoking cessation installed. And but in talking to actual people who are smokers inside our population, 87% say these incentives are very valuable to help them start the tough process of making a life change, like smoking cessation. And then you see there, additional information. But the research shows that essentially combining incentives with disincentives can double the success rate of these programs. So not just offering them the carrot of additional money or other things for completing actions around smoking cessation, but until you're faced with a out-of-pocket increase or a premium contribution increase, you're just not going to get the same results. And then what is the downstream result of that in terms of overall costs to all employees, especially including the non-smokers, of course? And the answer is it's quite high, and I think that's the source of the employer's strong feelings about this.
Mm-hmm. One other requirement that's not on the chart, but it's important, is that there are enhanced confidentiality rules. For wellness programs that are part of a group health plan, basically you have to comply with HIPAA's privacy rules. For wellness programs that are not part of a group health plan, the EEOC proposed reg includes a set of rules that will need to be complied with. One of the requirements is that you are only permitted to disclose aggregate information to the employer, and the information must be sufficiently aggregated so as to not be likely to disclose the identity of a specific individual. The employer must also take steps to protect the confidentiality of employee medical information. You'll see there on that first sub-bullet there, training of individuals who have access to medical information, adoption of policies, privacy policies and procedures, online systems and other technologies to guard against unauthorized access, and an individual who handles medical information should not be responsible for employment-related decisions. So if you are in charge of hiring and firing, you should not also be in charge of intaking of any HRA forms or other sorts of medical information that is relevant to your wellness program. Bryce, what are your thoughts as to this in terms of your prior comment around, I guess, regulatory or notice fatigue by employers?
Yeah, I know that this is, again, another area where you're going to find trying to manage these programs in a new, more highly regimented way is just going to be challenging, and it's workload on the internal HR staffs at especially large employers, and especially those with very disparate populations, and maybe even those with a 50-state footprint. Very, very challenging to manage all this type of data and information, and of course manage the confidentiality, and of course abide by HIPAA and the ACA rules on confidentiality, and then layer in now essentially a new requirement.
The EEOC has requested comments on numerous issues, and these two here I think I really want to highlight because they show a concern by the EEOC, and if this concern were reflected in the final rule, it would likely be something that employers would not be happy about. One is whether a wellness program should require prior written knowing confirmation by the individual that they are voluntarily participating. This would mean you have to go out with a notice effectively, and you say to people, I am seeking your written confirmation that you are participating in this program voluntarily. Please sign here. I think most employers think this would be a very difficult requirement to operationalize, would be the sort of thing that is unnecessary in light of the broad notice requirements that are already required under HIPAA around reasonable alternative standards, et cetera. And I think most employers would want to move away from any sort of written prior authorization or confirmation. The second sub-bullet here I think is also very important because we think the commissioners at the EEOC, several of them, were very focused on this idea that on top of HIPAA, basically any program that includes a disability-related inquiry or a medical exam must not render the program unaffordable using sort of Affordable Care Act or employer mandate principles. And this, I think, goes to their point that if you look at HIPAA, HIPAA says the incentive cap is based on the total cost of coverage. Well, in our example, it was $4,500 was 30% of employee plus one coverage. Their concern is that might be not that that $4,500 may not be overly significant for me, as let's say a higher paid earner at the company, but could be very significant for a lower paid worker at the same exact company. And it's the idea that what is voluntary for one person may be not voluntary for another when it comes to absolute dollar amounts. Obviously, if this sort of idea were imposed on employer programs as part of the final rule, it would require a much more individualized analysis around the extent of an incentive that could be provided with respect to a given employee, likely based on their wage or based on their modified adjusted gross household income, of which most employers have no knowledge. But I think these are two areas where we will see a lot of employer comment, and I suspect that if these found their way into the final rules, employers would be very unhappy. Oops, excuse me here. I think I doubled. There we go. A couple other issues. Bryce, I know we've talked in the past about the caddy tax and the growth of HSAs as a strategy. You want to jump in here?
Yeah, just to keep it brief, nothing new there other than you're going to see continued cost shifting happen to the employees, and incentives are a way that they can not necessarily give away free dollars, but can use additional dollars to help people engage in managing their own health care. Naturally, you would suspect that people would want to do that because more of their own money is at risk with a higher deductible. But employers, certainly the vast number of employers we work with, they want to help their employees. And so anything that limits that in an environment where they're already going to be on the hook for more, we think needs deeper thinking.
Thanks a lot, Bryce. In terms of next steps, here is a very, I think, concrete and brief analysis. One is if you have an existing plan, you really need to look at these regulations and think about how they apply to your wellness program. First step there, again, is figure out which of those three categories your program is in. We would expect the final rules to be fairly similar to what we currently have in the proposed regs, probably with some modification. But really now, look at those regs, understand how they apply to your program, develop a game plan based on possible scenarios. They're trying to get the final regs out, we understand, by the end of the summer before Labor Day. Raises a big question: how would these final regs, if issued, apply to your 2016 plan year? Certainly would not give you a lot of time to make change. So it's even more important because of the timing issues, I think, to think about how those regs could apply to your program. If you're designing a new plan, you might want to think about trying to fit within the proposed regs based on the theory that I just said, that the final reg will look pretty similar to the proposed reg. That way you're minimizing your risk. You could choose potentially to look at HIPAA really as your floor from a compliance perspective, but you may find yourself following the issuance of final EEOC regs having to make changes. In terms of what next, there is some legislation pending before Congress. We understand that's on hold while the EEOC rulemaking continues. Congress wants to see what the EEOC does. As mentioned, comments are due by June 19th. I did say final regs on the ADA issue are expected by the end of the summer or by Labor Day. I believe that's a pretty optimistic deadline. I'm expecting them to be pushed. I also mentioned early on in the slide on our webinar today that they are intending to do a corresponding GINA regulation. Now, one thing to keep in mind here is that even though we only have a proposed reg and it will eventually be finalized, regional EEOC offices are still sort of compelled to engage in investigations regarding potential ADA violations. So if you have an employee in a program who goes to the Chicago regional office and says, I believe my employer's wellness program is discriminating, that regional office is compelled to investigate that claim. They are likely to look to the proposed regs as a place to measure your program's compliance. If you are within the confines of the proposed reg and compliant with those regs, the good news is that probably is going to be a way for the regional office to say, okay, there is no violation, we're moving forward. If it turns out that you're not in compliance and you're waiting for that final reg, that may create some risk for you. On the other hand, I think a lot of employers are looking at this and saying, if I change now and the final reg's going to come out in a few months, then I might have to change again. So I'm going to sort of look at my risk, I'm going to determine my risk appetite, and maybe I'm going to just sort of double down with my current arrangement until that final reg comes out. I think that's probably a very wise strategy unless you have one of those programs like a very aggressive gatekeeping model, et cetera, because otherwise you may end up having to make a two-step or change now and change again. In terms of what next or consider taking action, up here we have the actual website where comments can be submitted. It's www.regulations.gov. until Friday, June 19th to submit comments. If you're a member of an association or other industry group, certainly you could work through them to put comments in, but definitely expect, I think we should definitely expect that there will be a host of comments, both from not just from employers, but also from disability rights groups and others that may think the EEOC proposed reg didn't do too much, but in fact didn't go far enough. And so I think it's really important that employers and employer groups work together to get comments in to make sure that we are expressing our views on these regs. With that, I'm going to now turn it back over to Jenny.
Thank you, Seth and Bryce. I really appreciate it. We have a lot of good questions that have been asked by the participants, and we're getting close to cutoff time. So for those of you that can stick around, I think we're going to get quite a few great answers from these folks. I'm going to ask as many as I can. Of course, we'll capture those that we don't get, and we'll get them out to you. My first question I see here is, while wellness plans have engaged people with exercise programs and spiffs to get their biometrics, you discussed making meaning of data as key. What do you really mean by that?
Yeah, so I should probably address that. So,
thanks.
And I'll give sort of a preview. I mean, all of us are aware of the Apple iPhones have been out for years. They're tracking your steps currently. We're doing an installation with an employer with several thousand Fitbits being put on the wrist of their actual employees in stores, gathering data about their general health and then mapping it back to them to see, how it can inform their overall health. And so you have these really new, very exciting devices coming to market. We just integrated with what's called the watch kit for the new watch. There's going to be 4.2 million units of those shipped in the next 2 or 3 months, if analysts are correct. And that is going to provide people with just very interesting information that folks like ourselves and many others are trying to turn into actionable health information back to the member. So that's what's coming.
Thank you, Bryce. Another question here. What if my wellness program falls into more than one category and I have program components both inside and outside of the health plan? How do I manage all of that and ensure that I stay within the new guidelines?
It's a great question, and I think as a general matter, the EEOC regs and even HIPAA sort of look at your wellness activities as if you really have a single plan. And I think what you're sort of getting at is a really good point, which is that employers may have a robust sort of wellness program that may have significant medical care or significant medical premium subsidies or rebates, and that's only available for folks enrolled in their major medical plan. And so you might have one that's sort of a group health plan connected arrangement. But then you might also have for all your employees, not just those enrolled in your major medical plan, you may have other ancillary wellness activities like health fairs, et cetera, raffles, incentives, things like that. I think really from that perspective, you should look at each of your activities and think about whether or not they're really part of a larger administrative scheme. If you have one arrangement that is really only available to one group of people and you're communicating it in one way, then all of all of the activity that happens in that arrangement probably is all bundled together. So if aspects of that throw you into the group health plan world, that's going to be good news from that incentive piece that we talked about. On the other hand, you may have things that really aren't part of that, like the health fair for all your employees or other sorts of things. And you can't really bootstrap those together because they really are a separate arrangement. So, I think looking at each piece of your puzzle and sort of bucketing them as appropriate is really what you need to do in looking at your risk.
Thank you, Seth. Great information. A couple more questions. Let's see, this one. If the minimums is not defined, how can I go with cash incentives or gift cards for my employees? I think I understand that. Is 250 okay, for example? Hope that makes sense.
That's a great question. They're basically saying I use cash. I'm not. It sounds like they're in Category 2, not Category 3, so they can't use the 30% incentive, but they can use the de minimis incentive in the proposed reg. And what does that mean? And they're sort of looking for sort of an outer limit on what is de minimis. I think 250 probably gets to the point where it's more than de minimis. it's not set forth in the regs. I think as a general matter, I would probably be in the $100 range or less. Why is that? Because under federal tax law, if somebody were to give you $100 of wage, that could be treated as de minimis under federal tax rules and not actually have to get reported. As I mentioned, one of the EEOC staffers went up to 150 based on their GINA reg. But as a general matter, I think once you get beyond 100, 150, it starts to look not de minimis. So, I don't know that I would change my program right now, but I would at least be aware of the risk and wait to see what happens with that final rule.
Thank you so much for clarification there. I'm going to ask one last question. Again, in the interest of time, we'll try to capture everyone if we haven't gotten all to your questions, and we'll try to get answers out to you, and I appreciate you hanging in there. This last question, I have two different health plans, and one is a lower premium, higher value plan with additional benefits, but it's bundled with the wellness program and only open to those employees who complete the biometric and cancer screenings included. This structure is really driving a lot of engagement, and it has the most growth as intended. Will I need to change this structure moving forward?
This, I think, goes, Bryce, to your to the gatekeeping example we had, and I know you have some employer clients who use similar arrangements. Bryce, do you want to jump in with your thoughts on that?
Yeah, I'll jump in from the employer perspective, and maybe you can add the legal perspective, Seth, and we'll close it out. From an employer perspective, I think their answer would be, we certainly hope not, because this is very much a strategy in place at a lot of major employers and continuing to grow, whether it's directly as the sponsor of a plan or through a private health exchange. And it's a very effective way to both provide the full ACA required set of coverage, and then also engage the member in their own health and get them involved in things like cancer screenings that can be extremely valuable in terms of early detection and creating more great stories and great wellness outcomes. So I think the answer from an employer perspective is they would hope not. And Seth, maybe you can address what you think might happen with the final rule.
Yeah, I think on the proposed reg right now, there's language, and we talked about it. It's back on the voluntary slide. I think it's the third sub-bullet under the voluntary standard, or maybe it's the second one, excuse me. It says that you can't effectively gatekeep or restrict access to not only a different plan, well, it says two things, to a specific plan or to another benefit package within a plan based on not participating in a wellness program. And I think if you sort of look at your arrangement in light of those words, I think the EEOC commissioners on the proposed reg would say that your arrangement is at risk because in order to access that coverage option, that other plan, you have to agree to participate in certain wellness activities. So I think it's definitely at risk. As I mentioned, I think there is a desire on the part of the employer community to say, sure, we understand that there are competing interests, and if you're gatekeeping access to comprehensive major medical coverage, period, meaning if you don't participate, you don't get comprehensive major med, that seems, maybe wrong, and we understand that. On the other hand, if what you're doing is taking away one of our tools in our tool belts to increase engagement with respect to programs that under HIPAA are non-discriminatory, we're not in support of that. And I think we're going to see a lot of comments for the reasons Bryce said, really trying to encourage the EEOC to narrow that restriction that they have under the voluntary standard to basically only where you're excluding all access to comprehensive major med, not when you're trying to drive engagement and effectively otherwise providing as a default comprehensive major med. So we'll have to see. If the final rule keeps the same language as the proposed rule, you probably have a problem, but that's I think, still under consideration by the EEOC.
To the person who asked the question, make sure you comment to the regs. Tell them your story.
Any final words, Seth?
No, I completely agree with Bryce. Like I said, the EEOC reg has a lot of attention. It's going to get a lot of comments into the commission, and if there are aspects of the rule that you as employers love or hate, and why, that would be really great for the regulators to hear.
Thank you so much to both of you. Really great presentation. Already getting emails as we speak, just thanking us for providing it, the materials. And as we, start to hear what final regulations actually come into play, we'd love to have you back and maybe get some definition on, okay, here's the final. But thank you very much. And for those of you on the call that have stuck around, thank you for sticking around for the few extra minutes. And Bryce, thank you so much for your time. And hopefully we'll get together again soon and be able to bring this material out to our constituents. And again, I already mentioned we'll be sending this replay to you for you to read, and I'll talk with the presenters a little bit later about whether or not we can show the slides in PDF format. Once I know that, I'll get back to all of you. Thanks again, you guys.